Hi, my name's Julie Ford and I am the owner of Gothard Row Landlord Services. So today I'm going to be talking to you about deposit protection claims. Now this seems to be a new trend that's sweeping the industry at the moment. Solicitors have obviously had not a lot to do with the eviction ban going on through coronavirus, and they've looked at other business streams for their income, which is totally understandable. However, this seems to be at the detriment to landlords. Now, what I have started to see is a lot of these no-win, no-fee solicitor firms are actually contacting tenants or being contacted by tenants who think that their deposit hasn't been protected or hasn't been protected correctly. Now, what this has resulted in for landlords is what I can only describe as completely threatening letters from these law firms demanding thousands and thousands of pounds in regards to compensation for non-protection of deposits. Now, yes, absolutely, if a deposit hasn't been protected correctly or the prescribed information hasn't been issued to the tenant correctly, a tenant can apply to court for a penalty against that landlord, and that is up to a maximum of 3 times the deposit value. So, for example, if your deposit was £1,000, the penalty could be up to £3,000. Now, the 3 times limit is very rare to be dished out to landlords, especially if you're a first time of doing it wrong, or you've done everything right but technically something went wrong. You protected the deposit but didn't give the prescribed information, or you've put the deposit into a bank account rather than protecting it. And there's lots of mitigating circumstances that go with it. So the 3 times the value is usually for what we see as repeat offenders, landlords that continue to not protect the deposit even though they've been told otherwise, and letting agents that basically should have known better. So what I see from these letters is just an opportunity for solicitors to make money. And I'm sure that they are misguiding the tenants in relation the information to them about the 3 times the value. I'll give you an example of some of the landlords that I've been working with recently and how I've managed to overturn these claims from the solicitors. Now, first of all, I want to just say not all solicitors are the same, and there are some amazing solicitors out there. Unfortunately, we're working with a minority, and they as well do not have any housing knowledge whatsoever, which is demonstrated in the letters and some of the case law that they're trying to rely on. So my first one was a landlord. He had a property which was attached to his own property. It was an annex. He'd sought advice from a local letting agent who had told him, no, it's definitely an annex and you are a resident landlord, deposit doesn't need to be protected. So he followed the rules. He followed exactly what the property professional had told him. When the tenant went to leave, the deposit was given back to the tenant minus a couple of dilapidations, £100 if that, which was all agreed with the tenant. A couple of years later, the tenant has obviously seen an advert for no win, no fee and come back looking for the landlord. The solicitor's firm wanted 6 times the value of the deposit because they claimed the deposit wasn't protected originally, and then when it went to a short periodic, a statutory periodic, they claimed a second set of breaches. So they wanted 6 times the value of the deposit, which was £3,500. Now, looking into it practically, the mitigating circumstances there was the landlord hadn't done anything out of malice. They'd sought advice and worked off that advice. Now, absolutely, they have breached the regulations. They hadn't protected the deposit. So I went back to the solicitor's firm and I laid all this out to them, the fact that the deposit had been protected to a degree in a dedicated bank account. It hadn't been touched for the entire time, and the tenant had got the deposit back minus the dilapidations that had been agreed. So it wasn't like the landlord was keeping the money or trying not to return it to the tenant. So eventually, going backwards and forwards with the solicitor, a couple of letters, it was agreed that the landlord would pay a compensation to the tenant, pay a penalty, and that would be 1.5 times the value of the deposit. So eventually all that was paid across was £950. Very, very different to the £3,500 the solicitor was looking for. Now, my second claim basically was the largest claim I've ever seen so far, and it was for £32,500. Now, this related to 8 tenancies. and interestingly, all for the same tenant. Now, the £32,000 was broken down into the 8 tenancies. The deposit hadn't been protected. They'd all gone on to statutory periodic, so again, a second set of breaches had happened. But when I looked into this, because you know as well as I do, an assured short hold tenancy can only be issued to an individual, and it has to be their main and principal home. Now, if this deposit related to 8 properties and 1 tenant, no way can that tenant live in all 8 properties at the same time. Not possible. So I had a bit of a dig. Company's house comes in useful, and I found out that the tenant was actually a rent-to-rent company. An AST, an assured short hold tenancy, had just been issued in error. And basically the deposit never needed to be protected because there was no assured short hold tenancy. Literally one letter to the solicitor's firm and they went away quietly. We never heard from them again. Now, the moral of this story is just because you're getting a letter from a solicitor or a law firm, it doesn't mean they are right. A lot of these solicitors, as I've mentioned, have no legal background when it comes to housing, no housing law knowledge whatsoever. And they are relying really on case law that has been and gone, been superseded by acts that they haven't had the time to research. So if you get one of these letters, please contact me first before you reply, because it's quite possible that you don't have a claim against you at all. And if you do, I'm quite sure that I can get that reduced down to something much more realistic. Yes, if it goes to court, you'll have to pay the other side's costs. But at the end of the day, we can avoid court because judges don't want to see these in court. This is not what judges trained to do. We can work this out with these solicitors and 9 times out of 10 I can get the claim wiped and it goes away, or I can get it reduced to a more realistic and reasonable amount of money. So if you have one of these letters, get in touch with me today. It's Julie at Gothard Row. So my email address is advice@gothardrow.com, or you can phone me on 07904 288 188. I look forward to hearing from you.